Good morning, Judge.
Hi.
Today's courtroom moment is not just dramatic, it is a legal maze. In this hearing, we watch Judge Nain get pulled into an immigration standoff with ICE, a passionate defense attorney quoting constitutional law, and a bond situation so tangled even the judge admits this has never happened before. The defendant in ICE custody, the charge, DWI. But here's the twist. He already posted bond, and now the question becomes, should the court revoke that bond just because ICE refuses to release him? The defense brings firepower, constitutional clauses, immigration policy, and due process arguments, all to prove his client is being punished for something completely out of his control. Meanwhile, the prosecution says this man is a flight risk, a danger, and ICE will not budge. One wrong move from the court could mean favoritism, lost jurisdiction, or a dismissed case. The stakes are real. So what happens when a criminal court collides with federal immigration policy? Stay tuned, because we are breaking down the judge's rulings, the legal risks, and the ethical tightrope walked in this stunning courtroom debate. Would you hold a case open for a deported defendant, or revoke the bond and move on? Let's get into it.
I just want one thing I'll say. I have my client here on video. He can identify himself if necessary. I'm gonna just put my camera on. So
This is a first for me.
It's a first for the ICE supervisor I just spoke to as well.
Wow.
This is,
I mean, wow.
I don't.
Mr. Feldman, that's some good work, man.
I'm
Great
an
job.
immigration attorney, Judge. So I mean, and I'm a salaried employee.
Yeah.
Really great job.
Well, I just mean if I wasn't a salaried employee, maybe it wouldn't be worth my time. I think that's an issue.
But representation is representation, doesn't matter, you know, really, at the end of the day, everyone is. Shh.
I don't believe that. I mean, I spoke to the ICE supervisor and even he said, I.
Well, hold on. We need to go on the record. Sorry, Miss Top, give me a second. Are you ready, Ramon? Okay.
Order in the court, going on the record.
So, Mr. Feldman, what's the last name again?
Carl.
We're on the
Carl.
record.
Thank you. What's his last name again?
This is Cesar Moises Capriel Perez. I think he's listed as Moises Perez on the.
Moises Capriel Perez, Judge. I have a cause number.
Yeah, okay, let me have that,
Okay, it's
please.
529290.
Okay, all right, sorry, let's go on the record. All right. We are on the record. It is cause number 252-9290. Today is December 10th, 2024. It's approximately 9:44 in the morning. Parties, I'd like you to announce yourselves for purposes of the record, please.
This is where it gets interesting. Right out of the gate, we see a courtroom first. The defendant appears via video from ICE custody, with no translator present and no clear understanding of what is happening. Let that sink in. The attorney, Mr. Feldman, takes the spotlight, calm, prepared, and clearly seasoned in immigration defense. He is already earning points with the judge, but what he is about to do next sets the tone for everything. Submit a massive stack of 10 exhibits. Everything from ICE detainers to bond documents to prove his client's rights are being trampled. The prosecution, not happy. They need time to review. And honestly, can you blame them? Question for you. Should courts delay rulings when one side is caught off guard, even if it slows down justice? Because this debate is only just beginning.
Beginning with state.
ADA Rojette Saba and ADA Kelsey Siegler here for the state.
And this is Noah Feldman on behalf of the defendant, Cesar Moises Perez.
Okay. You requested this hearing, so I'm going to let you start.
Okay, Judge. Well, before I start, I have 10 exhibits. I sent it to the chief last night, and I believe she forwarded it to Ms. Saba. I moved to admit those exhibits, tender them to the state for any objection.
And Your Honor, we would need significant time to look over these because we haven't been able to do so since they were.
Yeah, I have 10 exhibits. It's quite a bit.
Judge,
I get.
if I may. The first exhibit is the ICE detainer. It was in Harris County possession. The second exhibit is the magistrate order in which the state requested an $1,000 bond, which my client posted. The third exhibit is basically an ICE form you can get off the internet. It's a stay of removal form that ICE allows people with final orders of removal to apply for stays of removal that allow them to stay in the country for a limited time and limited purpose. So what I just offer this to show that. I mean,
Is this his or is this just a generic?
generic?
Okay,
Exhibit 4 is going to be just proof that he's in ICE custody. It's a print off the ICE.
that's 4.
Exhibit 4.
Okay,
Exhibit 5 is the bond condition violation report. Exhibit 6 is from the DA portal, just showing the release time from the jail to prove that he was released to ICE. Exhibit 7 is the cash bond that defendant's wife posted. Exhibit 8, to be honest, is unnecessary.
okay.
Could withdraw Exhibit 8. Exhibit 9 is a sample order of supervision you can get off the internet. It's just standard ICE form. And Exhibit 10 are this court's procedures that are available on its website about failure to appear and non-appearance. Those are the 10 exhibits.
So for purposes of the defendant, so record, I want to make it clear that Mr. Feldman has his computer and it looks like I can see the defendant there and it looks like he can look at us as well, but there's no translator. So does he understand what's going on?
Now we get to the meat. Attorney Feldman is walking the judge through each exhibit with surgical precision. Some are hard facts, ICE paperwork, bond violations, jail release logs. Others, just internet forms used to paint the bigger picture. But he is making one thing clear. This is a system problem, not his client's fault. It is a smart move. Flood the record with so much procedural logic that the court sees ICE detention as an uncontrollable force, not a choice. And remember, this defendant posted bond. He followed the rules. He just never got released because ICE stepped in. Legal twist. The judge is being asked to make a ruling that basically collides with federal immigration enforcement. Should courts be forced to honor bonds when ICE refuses to cooperate? We are now in constitutional territory, and it is only getting hotter.
That is correct, Judge. I do not believe he understands what is going on.
So now state, how do you respond to the exhibits?
Judge, I did not get these exhibits until my chief forwarded them to me while I was in docket today, earlier this morning. I'm gonna need time to review these. I'm not an immigration attorney, so I'm unfamiliar with these documents. I would ask for at least a day just to, or, I mean, if you don't wanna roll it to tomorrow, just like an hour or so I can read through it.
Sure, of course.
And that's
And we did speak, or
I spoke to the ICE supervisor, Judge, the one handling his ICE case. His name is Jeff Hudson. I relayed defense's requests for an order of supervision, and the officer said, he declined the request. He said that there would be no way that they would release defendant given that he is a flight risk and his assault charge makes him a community risk as well. He also advised that the defendant has been deported before. He advised that the only way to get the defendant over to this court is if you issue a bench warrant, and then they would review that warrant and decide whether or not they would transport him over here, which is what I advised defense before. He also said that we can try to work out the possibility of the defendant giving a virtual plea, but in terms of them releasing him.
But we need a thumbprint. I need a thumbprint. I need his signature.
Yes, Judge.
There's no translator there for him now.
Yes, Judge. He also did say that the officer did also tell me respectfully that we don't really have jurisdiction to litigate this immigration issue.
Sure. What you want is you do not want me to revoke his bond.
That is correct, Judge.
You want me essentially to hold this case open because he's going to get deported, right?
That is my understanding.
Boom. The prosecution just dropped the IC bombshell. IC refuses to release the defendant. Why? Prior deportation, flight risk, assault charge, that is their stance. But here is where it gets legally messy. IC says, you can issue a bench warrant, Judge. We will consider it. Not confirm, not obey, just consider. Now the courtroom is frozen. because no one really knows, does the court even have authority here? The prosecutor straight up admits she is not an immigration attorney, and honestly, that matters. This is a clash between local criminal courts and federal immigration control, and neither system wants to be the one to make the next mistake. Who do you think should have the final say here? The court or ICE? This hearing just turned into a legal standoff.
Essentially, what you want me to do is you want me to hold this case open indefinitely.
Judge, if I may,
Okay?
look, to me, for this court to revoke its bond based on these circumstances, I'd like to constitutionalize the objection. I think it would be, a violation of equal protection, procedural due process. I think it would be a violation of Section 11 of the Texas Constitution, which say that all prisoners shall be bailable. Section 13, which say that excessive bail shall not be required. Section 19, which says that no citizen of this state, I don't think they mean US citizen, shall be deprived of liberty, which this would be doing by revoking his bond, without due course of the law of the land. Now, the Texas Code of Criminal Procedure is very clear. When a defendant has once given bail for his appearance, he shall not be required to give another bond. That's 17.09 paren 2. This defendant, all he has done is posted the bond that the state requested, which is in Exhibit 2, which back after the ICE hold, the state requests a $1,000 bond for the defendant. Defendant posted the bond and without any volition on his own gets taken into ICE custody. I think you would agree with me, Judge. The state has the burden to prove a bond violation. There is a bond violation report. I think we should all agree there's been no bond violation because he had no ability to get an ignition interlock. He had no ability to report to pretrial. So the only exception to this one bond are the following. If the bond's defective, there's no defective in the bond. If the bond is excessive, nobody's arguing the $1,000 bond was excessive. If the bond is insufficient in amount, which is very broad, but I want to make clear that there is no amount of bond, as Ms. Saba just said, that can guarantee that my client can attend court. There's no amount. We could set him at $1 million bond. So I don't think insufficient in amount is correct. The only other catch-all is good and sufficient cause. Now, I did some case law research on good and sufficient cause, and these are new or changed circumstances from which the court can conclude that some cause exists for revoking a bond and setting a different bond. Now, as I said, the only bond that this court could set that would guarantee my client comes to court would be a bond that is impossible for him to post, right? Because any postable bond, he would have no control in getting to court. Now, ICE, if I may, Judge, I understand what Ms. Saba relayed that the ICE officer said, but I can tell you that 8 CFR section 241.5 allows ICE to release anyone on an order of supervision if they're subject to a final order of removal. If you look at Exhibit 1, the ICE detainer, it says that if you need this subject to remain in the United States for law enforcement purposes, you can call this number at 936-520-588. Oh, sorry, that's the wrong number. 802.
Strap in. This is where the courtroom becomes a law school masterclass. Feldman launches into Texas constitutional law like a machine. Equal protection, due process. Section 11, 13, 19. He is hitting every civil liberty button available. His argument, revoking bond now would be unconstitutional. His client posted the exact amount the state asked for. He did not violate conditions. And ICE custody. That is beyond his control. This is not just defense. This is a direct challenge to how the system handles non-citizen defendants. And the logic, sharp. There is no amount of bond that guarantees appearance if ICE will not release him. This is not about whether he followed the rules. It is about whether the rules even allow him a chance. Should posting bail guarantee protection from further detention, or is that a privilege only some can access? Feldman's fighting hard, but will the judge bite?
872-6020. And ICE can consider whether the law enforcement purposes are serious enough to keep the person in the country. Now, I think it would be punitive to take away $1,000 from somebody who posted a bond that this court affirmed, that the state requested, and say, I'm taking away your $1,000 because of actions completely out of your control, actions that are being taken by a third party.
So if I bench warrant him back here, then nothing will happen to that then, right?
A bench warrant is a revocation of bond. Because if you bench warrant him, basically you're asking the sheriff to go get him, or you're asking ICE to bring him. ICE has already told Ms. Saba, we're not bringing him. The sheriff, if they go recover him.
No, they haven't said they said they were going to think about it, that they were going to look at it. They didn't say that they weren't going to.
Well, then let me clarify, Judge. If you want to bench warrant and be clear in that bench warrant that this is not a revocation of bond, I have no objection to that bench warrant. It's my opinion.
You had an objection last time to the bench warrant.
I have thought about it some more, Judge. If you bench warrant him, but there's no revocation of bond, I have no objection.
Well, then we're all happy.
But
Are you happy with that?
Yes, Judge, I'm
Great.
fully deferring to you.
Let's do it.
This is what courtroom chess looks like. After all the legal back and forth, we finally reach a tense compromise. The judge agrees to issue a bench warrant, but with a specific note that it is not a bond revocation. That subtle distinction. It is everything. Why? Because revoking the bond could mean the $1,000 his wife posted is lost forever, even though he did nothing wrong. But without revocation, ICE might just ignore the court's order. So the judge is trying to walk a tightrope between not punishing the defendant unjustly and not creating legal loopholes for future abuse. This is jurisdiction versus fairness, and nobody wants to be the one who sets a bad precedent. Would you bend the rules to protect someone caught in the system, or play it by the book? Because right now, every move is under the microscope.
then let me say one more thing, Judge. I would request that on that bench warrant, it be clear this is not a revocation of bond. And let me tell you what.
Go ahead.
Because if you issue a bench warrant and there's no revocation of bond, the sheriff's office is not going to recover the body, because upon recovery of the body, they're going to have to release the body. And ICE could always, while he's in ICE custody, bring him, respect the court's bench warrant and bring him to the courthouse. I mean, I think he'd be in civil detention the whole time. I don't think they can put him back there.
Sure
But
they can.
Well,
They can.
I don't think they can.
Every
make
time we
someone
bench warrant them, they go right back over there.
because they're in county custody by that point. But what I'm saying is ICE can keep him in their custody, which is civil administrative detention, and bring him to court if they so choose. Now,
Try.
they
We'll
can
try.
try. They can try to do that, but I would just please ask this court, because I've seen it on.
I won't revoke it now, but let me ask you this.
Yes,
You
sir.
know, I'm supposed to be fair.
Yes, Judge.
I can't show favoritism, right?
Of course, Judge.
If I were to essentially, if he gets deported and I never revoke his bond, where have you ever heard that happening before? Doesn't that show favoritism toward you?
How would that show favoritism?
Because I'm doing something and I'm allowing your client to remain on bond for eternity when I've never done that with anyone else. Essentially, he's on bond for DWI. He doesn't have to comply with any conditions, no matter where he is, whether he's in Abu Dhabi, whether he's in Africa, whether he's in Mexico, whether he's in Guadalajara. He's supposed to not consume alcohol. He's supposed to be monitored. He's supposed to have an interlock. And thereby, I'm saying, okay.
This is where the judge pulls back the curtain and gets brutally honest. He flat out says it. If I let your client stay on bond forever, am I showing favoritism? That is the question courts never say out loud. And here it is front and center. The defense pushes back revoking bond would be punitive, especially when the client was taken by ICE through no fault of his own. But the judge is thinking about optics, precedent, and the dozens of other defendants who would never get this kind of leeway. This is not just law, this is courtroom philosophy. What is fairer, one person getting special treatment, or everyone getting treated the same, even if it is harsh? This moment reveals how justice is not always black and white. It is gray, messy, and full of impossible choices.
Here, look, you don't have to do any of these conditions. Everybody else does, but not you, Mr. Moises Perez.
disagree.
You are so.
I disagree, Judge, and here's why. The state of Texas works very closely with the Department of Homeland Security. The state of Texas, if they want to continue him on bond, which is their choice, because they want to continue the prosecution, they don't want to dismiss and refile, they can always put in a request that he be paroled back into the country for the prosecution, subject to the bond conditions. If you don't think that my client wants to remain in the country and follow your conditions, you are incorrect. We requested release from ICE. We requested that he be able to follow the court's conditions and abide by every single thing you put in that order.
You're apples and oranges. No, it's the point is that he's allowed to remain free on a DWI. Everyone else in our court has to follow a certain set of conditions, yet he's not going to have to follow those.
He should have to follow them.
And Judge,
There's
just
no supervision.
If there's proof
How
of
can I
him.
drug test him?
Judge,
How does he do the
then what's
analog?
the solution? The solution is either we're.
No. I'm going to bench warrant him. But what I'm trying to get you to understand is that it's not fair. I have to be fair to the state and I have to be fair to you. And I can't show favoritism. And I think that if I were to let him pass indefinitely without revoking the bond, if I were to, we're going to bench warrant now this is theory, right? As a practical matter, I'm going to bench warrant him here for you. But in theory, right, wouldn't it show favoritism? I think it does. Because I'm allowing you and your client to do something that I don't allow anyone else to do.
But wouldn't it be the opposite if you were to take $1,000 from him that he lawfully posted at the request of the state and this court at no fault of his own? I also think that's unprecedented.
I get it, but he's in this country. You know, the right way to do things is you ask for permission, you come here.
Judge, that's completely irrelevant.
Well, no, it's not. It's you must follow the law, period.
But he
And
got
when you
the-
don't, there are consequences.
Judge, he was given the $1,000 bond at the state's request
Again,
after we knew he had a final order.
I just wanted you to see it from my perspective. That's it.
understand, Judge.
Right. I'm going to bench warrant him for you. I'm not going to revoke the bond. We'll try to get him here for you. If for some reason at that point they don't, we'll cross that bridge when we get there. But we'll try to bench warrant. Did you want to add anything?
yes, Judge, the officer Hudson did advise me that if you issue a bench warrant, if you want to send me a copy of that, I can email it to him directly and as well as through whatever routes the court does it as well. But I can email it to him directly this morning if you do that.
That's incredibly expeditious because I tell you what,
Victory, sort of. The judge agrees to issue the bench warrant, and suddenly everyone's scrambling into action. The prosecutor is ready to send it to ICE. The defense has all the contacts lined up, and the judge finally praises both sides. You can feel the tension break, slightly. But do not let the calm fool you. This only works if ICE agrees to transport the defendant. The judge knows it. Everyone knows it. And if they say no, we are right back where we started. Do you think ICE will honor this bench warrant, or are we watching a slow-motion deadlock? One thing is certain, for now the judge has chosen fairness over frustration, but whether this actually brings the defendant back to court, that's a whole different story.
that it doesn't happen. You know what I mean? And it's literally when we issue a bench warrant, it takes a while to get to the appropriate person. It takes forever for them to think. It takes 3 months to bench warrant.
Judge,
So this is really
just to be
expeditious.
clear, I provided all the information, contact information for the ICE officers.
Judge,
Great.
actually,
So that helps, Mr. Feldman, you know?
Judge, just to clarify, the officer that defense tried getting me in touch with was not in charge of this case. Upon sending a message to that officer, he connected me to the supervising officer for this case.
Good job
That's a different-
to both of you guys. You both did good. The
I would just
idea,
ask to be CC'd on all communications.
sure, of course.
Yes, that's-
There's, everything's transparent here. No one hides anything. And I mean, I don't do the bench warrant. Usually Victoria does it, so I don't know the protocol to it.
Just
But
there's no
that,
notification.
so whenever, I guess when you send it via email, just if you don't mind CCing him,
Yes, sir. We always CC. Yes,
so
sir.
Of course,
Yeah.
Judge.
you're happy with that?
Yes, Judge, as long as there's no
Is happy
revocation.
too?
Yes, Judge.
Wonderful.
Thank you,
Thank you,
sir.
Judge.
Makes it for such a great, you know,
Thank you. I appreciate it, Judge.
off the record.
Thank you, Judge.
Good job. Way to be tenacious.
We didn't.
I'll just keep them. Yeah.
What a showdown. This case was not about guilt or innocence. It was about a broken system. A man held by ICE after posting bond. A defense attorney quoting constitutional law like a professor. A prosecutor stuck between immigration enforcement and courtroom procedure. And a judge who just wanted to do what was fair without breaking the law. In the end, judge issued a bench warrant without revoking the bond. A rare move that preserves the defendant's rights while giving the court a chance to regain jurisdiction. But this case exposed a harsh truth. When immigration and criminal law collide, there is no easy outcome, only hard decisions. It is cases like this that show how justice is not always about punishment. Sometimes it is about navigating chaos with integrity. If you found this case as wild and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Because this courtroom, never dull.